Welcome back. Will Worsham joins us now for this week's Speaking Legal Discussion. Good to see you again.
Hey, good to be here again.
Sort of.
Okay, fine.
You were making fun of
I
us
was
just a
making
little
fun
bit
of you.
earlier.
I was.
Oh, we'll let him go. Are you?
No White Castle for you.
Yeah.
Okay.
Yeah,
Yeah.
see? Picked
Messed
the
up,
wrong
didn't we?
day. You ready for the question?
I don't know now.
Okay, well, you better be. If I want to leave a portion of my estate to my grandchildren, can I skip over my children to make that request?
I love you, Grandma. So much.
Yeah. No, you can. You sure can.
It's your estate.
That's what
so,
estate planning is all about, is making sure that you get to do what you want with your stuff and give to the people that you want. You can skip over those kids and give it all to the grandkids. You can give some to the parents and some to the grandkids. Now, the caution here, though, is if those grandchildren are not adults. If they're minors, you can't make a direct bequest to them. You've got to put it in a trust of some sort. Yeah.
with
Otherwise,
someone in charge of helping dole it out at the proper time, right?
And, otherwise, if you just were to make a bequest to them and they were minors, then that would end up potentially in probate with, even though you used a trust to do it, because they can't take possession of it, a guardian would have to be appointed and conservator to oversee that money for them, which then they're going to have a fee and all that. So
At what age could they take possession
18.
of it? 18. Mm-hmm. Okay.
Now, when we're making plans for folks, you may not want them to get a large inheritance at 18. I don't know how you were, but you know, if I was 18 and you gave me a large stack of money, it might not last
Till you were 19.
till I was 19.
That's true.
So sometimes when we draft trusts like that, even though they can legally take possession of that at age 18, we'll draft the trust where maybe they get a portion of it at 18, and then a trustee's overseeing it, and that trustee can make some decisions. Hey, yeah, we'll pay for college, or we'll pay for medical care, or we'll pay for trade school, or whatever else out of that.
Could you avoid a trustee by saying, you know, once they're 18, I want them to get, we'll say, $20,000 a year?
No, that's what a trustee would be for.
Okay, I didn't know if you could set it up right away. All right.
There's always every
trustee.
trust has to have a trustee.
Okay.
So there's going to be a trustee there. Now that trustee may be a friend of yours, their mom, the oldest of the kids that's over 18, and they may not charge a fee for that. You know, the trustee may serve at no charge, and they can do that. But you can set it up to where they get part of it when they're 18. Anything that's in there can be used for other purposes that the trustee deems appropriate. They can get another chunk of it at 21, another chunk when they're 25, and then the balance when they're 30. However you wanted to do that, you could set that up.
Yeah, and there you can put pretty decent stipulations on it too. In other words, if you are wanting to put back money for the grandchildren's college or something, do you see often where people will say if you keep a certain grade point, or if you stay in school, or if you pursue this or whatever, then we follow through. But then what happens at the end if they don't follow through with it?
Right. There has to be an ultimate distribution of the assets. So they have to go somewhere at some time for some reason. And so if ultimately you have crafted a scheme whereby that bequest could fail for that beneficiary, there has to be a contingent or an alternate beneficiary for it to go to, and that might be a charity, the other kids, something like that. That seems kind of harsh. But you know, you could set it up if you wanted to. It's like, hey, you know, you're 18. If you go to college, you're going to get this amount of money. If you maintain a GPA, you're going to get a bonus on top of that. You can absolutely
an incentive.
do that.
Yeah.
Could you leave something that would accrue interest that isn't necessarily in a trust?
Well, you would put that in like an annuity.
Okay.
But you have no control over that annuity. When you put an annuity out there, it's going to pay out according to its schedule.
Yeah.
So there's really, if you're doing this type of estate planning anyway, there's no reason not to have it in a trust, because that puts the person you want to be in charge, following the directions that you leave for the people that you want.
Securities could be part of the trust, though, right?
You can put anything in the trust.
Yeah.
Now, hopefully, you're going to take what you want is your trustee to have a good financial planner, financial manager that's keeping track of that. We know some people that can do that.
We do.
Wonder who that would be.
Right, we sure do. But you can do that, but you want to manage it. You want that earning income.
Right.
Right?
Yeah.
That's the point of it. So that's why you have...
I'd been thinking in terms of, because I'd heard, you know, who knows when, about, going to buy city bonds, leave them to my grandchildren.
Sure.
And that will have matured up to this huge amount by the time they're 21 in an imaginary situation.
Might.
Yeah, in an imaginary situation, and if the kids are still around, All of that money is subject to a creditor at that point. So if the kids run up a lot of debt, if they've any type of scenarios, that money's not protected. But if you have it in a trust, you can protect it from creditors.
Yeah,
Find
get good
an
advice.
attorney.
Yeah, exactly.
Okay. If you have any legal question for Will, you can email him at wworsham@color10.com. He'll answer your question on the show.
All right, up next, it is not too late to sign up for the day trip to see the Passion Play with Advanced Tour and Travel. We'll tell you how you can do that. Stick around.